everyone, and welcome to the last session of the OECD Competition Open Day. I see that we still have a very good number of survivals, so I guess that everyone is waiting for the cocktail. Let me give you the good news first, and the good news are that this session is even going to be more exciting than the cocktail for two different reasons. First, because the topic couldn't be more interesting, relevant, and challenging, merger control in dynamic markets. And second, because we could not count with a more extraordinary panel of speakers. So I'll not lose any time, and I will introduce them right away. So starting my far left, we have Giulio Federico, who is the head of unit of the chief economist team of the European Commission, with a lot of enforcement experience, now I think for almost 10 years. Before that, Giulio was a guest professor at the Barcelona Graduate School of Economics. Giulio has published many papers on this particular topic, so we are very lucky to have him here. We have also Gail Levine. Gail Levine is a deputy director of the US Federal Trade Commission, where has been for 2 years now almost. As a deputy director, Gail has to oversee many important mergers in dynamic markets, some of them in healthcare, others in high technology. Before joining the FTC, Gail was at Uber, so working as head of the regulatory unit. And Gail has also much experience before in private and public sector, including at the DOJ, the Department of Justice of the United States. We also have with us Geoffrey Manne. Geoffrey Manne is the president and the founder of the International Center for Law and Economics, which is a very well-renowned non-profit center that does research in several topics, including the one that we are discussing today. Geoffrey is also a distinguished fellow at Northwestern University Center on Laws, Business and Economics. Geoffrey has also many papers published in journals such as Journal of Competition Law and Economics, Harvard Journal of Law and Technology, as well as others. And finally, at my far right, we have Helder Vasconcelos, who is the vice president of Compass Lexicon, one of the leading consulting firms in competition economics, and he's based in Madrid, and also full professor in economics at University of Porto. Before joining Compass Lexicon, Helder had many important responsibilities, including as vice rector at University of Porto, as a member of the board of ANACOM, the regulator of telecom in Portugal, and as a consultant of the Portuguese Competition Authority. So, as you see, we do not lack expertise in this panel. If anything, we have in excess. So, given the occasion, I don't want to waste much time saying a lot about the topic. I'll just say the necessary. So, by dynamic markets, we mean markets that change a lot over time. That's it. So, markets such as high-tech, telecom, media, banking, consumer services, online retail, the usual suspects. And the concerns about these markets, or the characteristics of these markets, include high innovation rates, product and process innovation, high levels of investment, a lot of strategic interaction. Firms take decisions on many levels, adapt their market position, they differentiate their products, and we have constantly firms entering the markets, exiting the markets. So the perfect scenario to make predictions, as you see. Given these challenges, I'm not going to waste any more time. We just want to discuss what are the effects of mergers in these markets, how can we adapt, if we should adapt merger enforcement to these markets, and I'm going to start with Helder. So, Helder, first question for you. I'd like to ask about what does the literature say, theory and empirics, about the effects of mergers. We know that in the short run, mergers can very often result in price increases, even if for a short-term period. But what happens in the long term? Are mergers good? Are they bad?
Well, thank you very much. Good afternoon. Well, in 2 minutes to summarize the merger literature is quite challenging. Let me just say that well, I will take the point that you just mentioned. I think there are essentially two things that I would like to say about the academic merger literature. The first one is that it is, even though it's a huge literature, it is rather static. and I think this is a caveat. And the other thing that I would like to highlight is the fact that it is primarily based on profitability issues, and the welfare implications of mergers are only taken at the second level of priority. And I think these are two caveats, I would say, that have been influencing the way mergers have been addressed by competition authorities.
But what do you mean with second level of priority?
Well, the problem is that, I mean, if you look at most of the merger literature, what basically you have there is you have a set of firms, and in some cases you have a firm which is for sale, for instance, and then you have some auction mechanism. And usually the firm with the highest willingness to pay for that target firm gets the firm, or you have some other kind of coalition formation game. And then basically they say this is the most likely merger that would come out of this merger formation game, so to say. And at the second level, then they say, oh, so let's now evaluate what are the welfare implications of these mergers. I don't think this is the right approach, because if you think about what happens in reality, actually a merger game is basically a game of strategic interaction between the merging parties and the antitrust or competition authorities. So I think that these two caveats are very important, because first of all, you should be able to anticipate what the ultimate market structure a merger is going to lead to if approved, and the antitrust authority is actually an active player of the game. So it's very unlikely that you are going to propose a merger to monopoly, for instance, if you know that this merger is not going to be cleared by the antitrust authority.
That's a very interesting point. And when we were studying this topic in the OECD, I have noticed that you have written several papers where you consider the impact of a merger on subsequent mergers. So you don't consider the merger as an isolated phenomenon, and you think, if this merger occurs, will other mergers follow? And you say that this is very important to try to predict what would be the ultimate, last structure of the market. But can competition authorities really do that work? Do they have the resources, and how should they do it? How can they predict how the market will evolve over time?
Well, first of all, I'm not the only one doing that kind of research. But yes, it's true that there is a line of the literature on endogenous mergers that acknowledges the fact that a merger has implications on the profitability, on the welfare effects of other mergers, of subsequent mergers. Okay, so and that literature basically highlights the fact that if you consider a forward-looking antitrust authority versus myopic, so to say, antitrust authority that only studies one-step deviations from the current market structures, most of the times, or many times at least, the conclusions are not aligned, which means that what a myopic antitrust authority does is usually not a good prediction of what's going to happen in the market, and you can have many mistakes. So the question is, your question is, how far should the antitrust authority look at?
Well, that's a whole other question. That's a very hard one, I know. But before you even go there, I want to ask if you have any example of a very practical application where looking at the ultimate structure of the market, predicting how the market will evolve, will affect the decision of a competition authority.
Yeah, sure. I mean, for instance, in one of the works that you probably were thinking about before, it's an article that I wrote maybe 15 years ago with Massimo Motta, in which at the time our criticism was basically the following. First of all, antitrust authorities, they claim that efficiency considerations are usually taken into account when they review the mergers, but you don't find a lot of cases and evidence that this is indeed the case. But at the time there was a huge discussion about what was the so-called efficiency offense argument, which is basically the case in which the antitrust authority thinks that after a merger, the efficiency gains resulting from the mergers are so high that outsiders would be pushed out of the industry after the merger. And so
the idea is that one of the firms will become so competitive that will kick the others out, and this will be terrible.
Yeah. And our point with that paper was very simple. We compared the forward-looking antitrust authority with a myopic one, And we realized that, I mean, while a myopic antitrust authority would probably forbid the merger because it expects that outsiders would exit the industry after the merger, a forward-looking one would kind of anticipate that after the first merger, it would be very likely that a defensive merger would occur between the outsiders because they want to match the efficiency gains of the first mergers. And actually, the industry structure which is predicted after the merger is consumer welfare beneficial. And this led us to conclude that the efficiency offense argument in our simple model didn't find any theoretical rationale.
So, if I understood correctly, if we consider the ultimate structure of the market and the fact that after a merger there will be other mergers, the efficiency offense argument makes no sense.
Yeah, within our simple context.
Okay,
yes.
so let me go now to another topic, because you were discussing the fact that a merger can result in other mergers, and competition authorities should predict that, so good luck for say that. But the next point is, but how affects other variables, other competition dimensions? We know how mergers affect prices, but what about innovation, what about investment?
Yeah, you mentioned that before in your introductory remarks. Well, the usual claim is that there are these short-run effects, which usually are price effects. But you should not forget the long-run effects, which are the incentives of firms involved in the merger to carry out investments in R&D, in innovation, and so on. Which is true, and the background note is very clear that was distributed here, is very clear about that, in highlighting the fact, and I agree with that the long-term effects might more than compensate for the negative, so to say, short-run effects, or vice versa. And so the short-run and long-run effects should be taken into account when you are deciding a merger. The only twist I would make here in this argument is that I think that we should not restrict attention to, in the short run, to price. So let me say in another way. So price effects are not restricted to the short run. This kind of literature that I was mentioning before basically highlights that you have short-run price effects, but also non-short-run price effects if you allow for subsequent mergers in your analysis. But in any case, what I think should be highlighted here is that, well, the short run that should be compared with long run effects in order to be sure that the overall effect on welfare, whether it is positive or negative. And in that case, innovation and incentives to invest play a crucial role.
Okay, that's a very good point, because what you're saying is that it's not only about innovation, not only about investment, it's also about prices. Beyond the very short term. And actually there is some empirical literature that has looked at the price effects of mergers, ex post assessments of the effects of mergers, and the few studies that look beyond 1 or 2 years sometimes found that those price effects disappeared. So the merger was not problematic anymore after 2 years. So that's a great point. I just have one last question for you. Clearly, from what you say, we can conclude that we should look at long-term effects, and we should consider if a merger will result in other mergers in the future. Now my question is, how long? Should you look at 5 years from now, 10 years from now, 20 years from now?
I think this is the $1 million question, so it's very difficult to... I think it's extremely difficult to answer what is the ideal time frame. Also because it seems to me that it depends on the industry you are looking at. In some industries, the speed, the rate at which mergers occur is very fast. In other industries, it takes longer. And also you should take into account the fact that, I mean, the time span that you need in order for entry and exit barriers to disappear in a certain industry varies from industry to industry. In any case,
should consider barriers to entry and exit when calculating that time frame.
Yeah. In any case, I mean, even if it's too difficult to answer your question, I think we could not simply go to the other extreme and not look at the future. So I think some effort should be done, at least require some information from outsiders to the mergers to understand what's the likelihood that they will embark as well on mergers afterwards. And this can be done, and you should not simply sit down on one of the extremes and carry out a pure static analysis. So
I just have one concern right now. I do not have $1 million here, so I guess we'll not address that question now. Now I maybe... I'll move exactly. So I don't have. So we are not going to get the answer. But I would like to move now to Geoffrey, because you have done some research also on the effects of merger short-term versus long-term, and you have submitted a very interesting paper to the OECD, and I'm very familiar with your paper because you asked me to review it. So this is the opportunity now to ask you some...
I suspect you're more familiar than I am.
Well, let's see that. So, what were the findings from this paper? I think they were in the wireless telecom industry. You assess the effects of mergers in the short, long term. What did you find out?
In particular, I should point out, we didn't assess the effects of mergers. We looked at the existing empirical studies.
So it was a survey of empirical
literature.
literature.
A review. And there, it turns out there's a lot of literature looking at the price and investment effects, both short-term and long-term, of 5 to 4 and 4 to 3 mergers in mobile telecom industry. There are also a lot of those mergers, and there's a lot of studies on them. So I guess I think we had 18 or 19 studies, if I remember right. And they covered, maybe you remember better than I do, the number of mergers, but it was in the dozens, I think, or around a dozen.
I do not remember.
In any case, a good number of mergers. So here's what I think is most interesting from the findings. The first interesting tidbit is only about half of these studies looked at anything other than the static short-term price effects. Now, that's relevant in part because, that's not relevant in part because many of these are academic studies and they're looking at it, asking a particular question and answering that question. More importantly, though, they are frequently used, regularly cited, for their policy implications, occasionally by the authors themselves, but more often by others. By
authorities.
By authorities or others advocating on behalf of or against a merger, for example.
And why is that a problem?
Well, it's not. It's a problem for the reason that Elder just suggested. If you're looking at a study that looks at only short-term price effects, it's hard to argue that you're actually doing a good job looking at the relevant consumer welfare effects of the merger, especially in dynamic markets. Now, these happen to be all related to mobile telecommunications, as you pointed out. There's an enormous amount of infrastructure investment. There's a pretty regular cycle of new technology that often requires substantial infrastructure investment. It's sort of a perfect example of an industry where it's hard to imagine how you assess the consumer welfare effects looking only at short-term price effects.
But if I remember well, some of these studies also looked at investment. So you had studies that look at prices, but also some that look at investment.
Right, so the other half of the studies consistently looked at the price effects and the investment effects. And what was most interesting, I think, about the literature, well, two of the things that were most interesting. One was whether they looked at investment or not. There was a wide dispersion of price effects found relating to the same mergers. So in some examples, you found a study that found a negative price effect from a short-term price effect from a merger. In others, with maybe a slightly longer time frame, you might find a positive effect. That's just important to note that there's a lot less certainty around these things than we often think there are. But the uncertainty gets magnified considerably, of course, when we're looking at dynamic effects and at a longer time frame and trying to determine what the consumer welfare effects might be. So in these other studies, while there was some disagreement on specific mergers of the price effects, the price effects were sort of all over the map. And the weight of the studies showed short-term increases in price following 4 to 3 mergers.
But not all of
them.
But
not
so
all.
There
no,
were some studies that showed
some
price
showed positive,
decrease.
some showed negative. There was quite a bit of dispersion. But every single study that looked at investment found positive investment effects. In other words, an increase in the amount of R&D or investment in infrastructure by the industry as a whole, if I remember correctly, both the industry as a whole and the specific firms involved in the merger following a 4 to 3 merger.
So you had an ambiguity in terms of price effects, but investment went always up, suggesting all these mergers were great for investments.
Suggesting. Well, but so it does really, raises the question what we can infer from that. I agree with Helder completely. It's essential to look at dynamic effects, but they're really hard to look at. So we use proxies like investment, and I think that's a pretty good one in industries like this, where we know what the cycle of investment and innovation quality increases look like. But even there, and certainly in other industries, it becomes a much harder question, both to determine even the direction of the welfare effects, but more importantly, if you're trying to evaluate and add together the short-term effects and the dynamic effects, it's really hard to know the magnitude. By definition, you're talking about something happening in the future. You're talking about very unique circumstances. That was one of the interesting things about this study as well. It's very hard, in other words, to say, well, this amount of investment increase happened from this merger in this country in this year, so we can assume the same amount will happen here. And we looked at that one from 5 years ago, and we can say the welfare effects were X, and they'll be the same here. You can't do that.
So I noticed some criticism.
What's the magnitude?
Yes, I noticed some criticism in your paper. As an economist, it was very hard to me to see how critical you are of the empirical literature, but something...
No, not critical of the empirical literature,
of
critical
how useful it is.
Of the policy implications.
I see. One of the points that I saw in your paper is that we should not go and cherry-pick the empirical literature that we want to make our case. So we have to look at the empirical literature as a whole and consider the full range of effects that we find. But I also found another comment, the comment that even the empirical literature as a whole does not necessarily give you the answers when you are assessing a specific merger in the future. Why not?
Well, that goes to this issue of the sort of unobserved or elided over differences in circumstances behind these mergers. So in the studies that we looked at, their mergers were in 7 or 8 different countries, I guess, with wide ranges of population density. And remember, again, we're talking about telecom infrastructure, so the population density may not be as relevant in other contexts, but here it's pretty relevant. You have different consumer demand for different types of products, different mixes of high-speed data versus voice time. Massively different regulatory environments. And of course, again, from the standpoint of the empirical literature, looking at a particular one or multiple of these mergers and trying to understand what the consequences might be, I think it's perfectly fine to assume away the importance of those environments. But if you're trying to make a prediction about how the next 4 to 3 merger will affect consumers in a completely different country where all of these factors are very different, I think it's more or less impossible to rely certainly on a single prior study, but even perhaps the massive prior studies. And yet that's pretty normal. And of course, when we get to talking to the enforcers, it's a real problem. I mean, what are they supposed to rely on if not that? And how are they supposed to make their assessments? Well,
that's fair. I just have one last question related to this study and another one that you published on the Journal of Competition Law and Economics, I think, so on innovation and the limits of antitrust. Mm-hmm. So in this paper you talk about the error cost framework and you say that we should be very careful about over-enforcing because when we over-enforce the market will not autocorrect, while if we under-enforce the market will tend to correct. So this is a case that you do in this paper of yours. In the paper that we just discussed, you say all the empirical evidence found ambiguous price effects, but the long-term effects in terms of investment were always positive. And you just said as well that it is very hard to use this literature to make predictions for the future, so authorities are in trouble. Now, given all this context and given that it's very risky to over-enforce and all the evidence, why bother? Shouldn't we put an end to merger control and not worry?
Yes.
Okay.
No, I could leave it there, or I mean... there's more I can say, but I do think that it's an incredibly difficult problem to overcome. We talked about it a little bit this morning on the keynote panel, the error cost framework and the relative risks of type 1 and type 2 errors, and we can debate, for example, the assumption that markets will tend to correct and that regulation will tend not to be corrected. I think it's fair to say those assumptions shouldn't be held as strongly as they may have once been. And yet, you're still left with this problem, right? We're still left, on the panel this morning, we're still left with a bunch of economists and enforcers and scholars who are essentially going by intuition, who are essentially saying, I don't know the answer to this, but regulators got to regulate, so we have to figure out a way to answer. We spent too long worrying about type 2 errors. Let's worry about type 1 errors now.
Well, the answer seems clear.
Well, no, that's the point, though. I mean, as much as in some ways the only really defensible answer is do nothing, but I understand why that's not really defensible. It's hard, however, to then pick any point on the sort of regulatory strength continuum and defend why you're there instead of anywhere else on the continuum, which is a bummer for regulators.
I feel I should move to the enforcers now because they are probably upset about the question that I just asked. So, Gail, should we put an end to merger control?
So one correction for the record, we are enforcers, not regulators. Look.
I can ask you a serious question.
No, go ahead. Look, the big picture point to keep in mind when enforcers are evaluating mergers is that, yes, disruptive, dynamic business models are challenging for all the reasons that have very thoughtfully and carefully been laid out this afternoon. I think that can't be gainsaid. But in a sense, it's sort of nothing new for antitrust. The antitrust laws, as the Federal Trade Commission chairman was saying this morning, the antitrust laws are sufficiently flexible to address anti-competitive conduct in these new and dynamic industries. An effective enforcement of the antitrust laws can ensure that the market is going to, that market incumbents are going to compete on the merits. Look,
may I ask, so in the context where you have such flexible merger enforcement tools, do we need to adapt them, or how can we apply them in this context of dynamic markets?
Well, fair question. So, look, we have to use our tools in a way that's very familiar, but in a way that is highly aware of the challenges of evaluating a dynamic market. The familiar sense, on the one hand, is, we view at the FTC mergers and conduct cases, too, right, in dynamic markets, just as we would for any other product or service. We rely on our expert staff of economists, of lawyers, of other professionals to investigate the merger and to find out by digging deep and hard into the facts of the individual case what the likely anti-competitive effects are. We ask, how's the deal going to affect prices? But we don't stop at that. We ask how the deal is going to affect quality, output, innovation. We ask that question in markets new and old, in markets static and dynamic. We ask all these familiar questions about how are consumers going to react to a change in quality, to a change in price? How will businesses react to that reaction? On the flip side, we're alive to the unique facts of each case, and where the markets are moving fast, we're awake to that reality too. An antitrust analysis turns on the facts, and in high-tech cases or dynamic cases, those facts are going to play the determining role. And we have to recognize that in dynamic markets, disruption happens fast, and we need to react to that. Remedies can be tricky, given that disruption happens so fast, and we have to keep that in mind as we're examining the case.
Well, those words are all very reassuring because they suggest that you do have the tools to deal with these markets, even though they are clearly complex, and we have many difficult effects to predict, as suggested both by Elder and Geoffrey. But let's put it now then in a very practical context. I know that you have overviewed many very high-profile mergers. I'd like to ask you about one, in particular the merger between Illumina and Pacific Biosciences. This was a very expensive deal from what I see. These companies, they compete on the market for DNA sequencing generation. So first of all, what is that?
Well, of course, you know that's how, that's a technology for ordering nucleotides for important scientific inputs. You knew this, of course.
Absolutely.
Yeah, that's what I thought, right? DNA, so yes, the market, this was a market between two players in the market for next generation DNA sequencing. It's a technology used for genetic research and clinical testing. You have to know the order of the nucleotides. I'm sure I'm garbling the science. There's a reason I'm a lawyer. But in any event, the important point was that from the user's point of view, the more sophisticated user's point of view, these were important companies in the space for next-generation DNA sequencing. We, the Federal Trade Commission, filed a complaint in December challenging the acquisition. The buyer was Illumina. Illumina controlled the lion's share, something like 90% according to our complaint, of this next-generation DNA sequencing market. Illumina wanted to buy Pacific Biosciences. It was one of the few firms, Pacific Biosciences, that makes and sells this next-generation DNA sequencing technology. According to our complaint, it had quite small shares, 2%, 3%, something on that order. And
what was the theory of harm?
Yes, so the theory of harm was that there was going to be competition lost today and competition lost in the future. Pacific Biosciences had been making innovation over the years that had continuously made its product better and less expensive. But it was becoming a closer and closer alternative to what the A side was offering. And it was a bigger threat to the A side of the deals, business than ever. But we also alleged in our complaint that they were poised to continue competing with each other into the future. You know, predictions are hard. But we had, we thought, strong evidence to show that Pacific Biosciences was poised to grow further at Illumina's expense.
Can I ask what kind of evidence? How could you make what kind of evidence you used to make these predictions? That will be a future overlap, future competition?
Yes, so I will stick to the allegations that we put in our complaints. As you probably know, once we filed our complaints, shortly after that, the parties abandoned. So there may not be an opportunity to lay out the evidence. But I'll answer your specific question in general terms. In all of our cases, we make sure, if we're going to challenge a case, we want to have three legs to our stool. We want to have strong evidence from a witness perspective, from a documentary's perspective, and from an economic perspective.
Okay. If I may react, I did a little bit of research about the case, and I saw how the merging parties reacted to the decision, and what I believe they said was that the technologies that they were developing were not really substitute, but they were actually complementary, so they would not really compete against each other. And they also added to this that some years ago, maybe a decade ago, one of the two parties had already tried to compete directly against the first and did not succeed, and that's why they eventually decided to differentiate enough and to develop complementary technologies that, if were brought together, would create many efficiencies. Did you consider these efficiencies, the fact that there could be complementarities involved?
Of course, and I will say that the case was very well represented, and they made very strong and helpful arguments. But in the end, we were persuaded by the evidence we saw that, you know, PacBio was continually improving its system to reduce costs and increase its throughput, take market share away from Illumina. And Illumina, sort of conversely, was kind of investing to develop the kind of technology that was more in the space of PacBio. And so because we saw these converging the story about convergence and in a future innovation story. That's what compelled us to challenge the deal.
I think that is all very clear. The only thing it's still not clear to me is what DNA sequencing generation is, but I don't think I will understand it today. So maybe for now I'll move to Giulio. So Giulio has a lot of experience also in innovation theories of harm, and I think I'll go directly to the provocative question, if you allow me. So I have seen that when the Commission started many of these cases, again, supported by theories of harm such as loss of innovation, and we have examples such as DuPont, General Electric, Alstom, and several others. From what I understood, the Commission was criticized because these theories of harm are novel and the literature is not clear about the impact of competition on innovation or about the impact of mergers on innovation. So, is this true? Is it that complicated, the relation between competition and innovation?
Thank you, Pedro. Thank you again for the kind invitation to be here. As usual, I speak in my personal capacity. Well, I like the FTC account of the Pacific Bio and Lumina transaction. That's really, a common sense approach. Are the parties close competitors now in the future? Do we see them exercising business stealing effects on each other? Meaning, if they were to succeed in their endeavors, would they steal market share from each other? If that's the case, absent countervailing efficiencies, that should be a concern in terms of dynamic competition. And the economic literature actually supports that common sense approach to innovation concerns. Once you really identify the business stealing effects that a merger internalizes and focus on those, both in terms of price, as Helder was saying, today's price and tomorrow's price, and in terms of innovation. So actually, some of the work that the Commission has been doing in the agrochemicals case, Dow, DuPont, and Bayer Monsanto, really didn't break new grounds in that sense. It simply went back to that economic literature, made sure that we were looking at literature on mergers, not on other competition variables that may vary, not due to a merger. For example, some of the literature looks about how, if demand is more elastic, what happens to innovation, or if products are closer to each other, what happens to innovation. You have to focus on what a merger does to competitive parameters and check what the innovation effect is. So I think actually the literature is in many ways simpler and more focused than one might think once you identify that we're speaking about merger control here, and a very specific change in market circumstances.
I noticed that you made this case very clear, so I also had to read that literature when working on this topic, and I was very confused for many weeks until I understand these theories of harm, and I made the theory simpler in my head. But I think in one particular paper that got you the Antitrust Writing Awards, you explain in a very clear way this relation between competition and innovation, and the fact that this theory of harm might not be so novel. And to explain that, you made a distinction between static and dynamic competition, ex-ante and ex-post competition. Could you maybe briefly elaborate on that?
Well, I guess there's 2 points to that. This is a debate goes back to Schumpeter, Marshall, and Adam Smith, if you wish. But it's basically, do we see competition as a dynamic process of rivalry where firms take share from each other, and in that process benefit consumers by introducing better innovative products or lower prices precisely to be more attractive to consumers? Or do we see competition as an end state of perfect competition nirvana, where resources are efficiently allocated, prices are marginal cost, but then nobody innovates because there are no rents to be earned from innovation? And Schumpeter was adamant that the first notion of competition is the one that matters most, is the one that delivers the most benefits, and in a way he was advocating authorities like us in the future to really focus on that notion of competition as a more important one. And once you do that, I think you quite quickly come to the conclusion that a merger may hinder the dynamic competitive process by internalizing those business stealing effects. And that's a traditional unilateral effects approach that we know from price that can be applied to non-price factors.
If I remember well the words of Schumpeter in his book, comparing dynamic competition with static competition is just like comparing a bombardment against forcing a door.
Yes.
So my follow-up question from this is, what of these types of competition does the European Commission promote?
Well, I think all authorities, indeed, if you see our work on advocacy, all the enforcements, we always say competitive markets deliver price benefits and innovation as well. And actually one of the key reasons to legitimize competition policy is the focus on innovation. So I think in terms of talking the talk, we do very well. Then when it comes to walk the walk, it's harder, because then you come into the real practical evidentiary challenges that Geoffrey and my colleague from the FTC has been talking about, on what kind of evidence you bring to bear in a specific case. In particular, when you're talking about complex markets, the ones you didn't even know about, medium to long-term processes, where firms themselves face lots of uncertainty, not just enforcers. So I think the challenge is really not the economics, I think. It's the evidentiary, practical challenges on a specific case.
Can I just add to that? I think that there's something very profound in that last statement, which is, it's important for us to be thinking hard about the economics and the theory and the overarching principles that govern all cases. But when it comes down to it, in an individual merger, the facts are so critical, and what you can prove versus what you think makes all the difference. Oh, can I take this opportunity also to say, to nunc pro tunc, my caveat that I was supposed to say at the beginning? I speak on behalf of myself, not the Commission or any individual commissioner.
I was supposed to say that on behalf of all the speakers,
yes.
But I strategically forgot it.
We both forgot.
But
now I can keep my job.
But before I go to the practice, I was enjoying the theory that you're discussing, and if you allow me, Giulio, I would like to ask you about a paper that, another paper now that you published with Gregor Langus and Tommaso Valetti on horizontal mergers and product innovation. So you did some economic modeling and simulation there to see what the effects of mergers would be on innovation. So what was your conclusion in that paper?
Well, that paper really tries to go back to the basics and say, let's use the most simple example of standard product differentiation models. Let's allow firms not just use price to internalize diversion effects between them, but also use innovation in future products. It turns out that typically there's two effects on innovation. I'll come back to consumer welfare, which is actually the more important parameter, but there's two effects on innovation from a merger. The fact that innovation diversion is internalized, meaning if I innovate and I steal market share from you, that factor is internalized and hence reduces my incentives to innovate. I cannibalize your sales. That tends to push down innovation, but the fact that prices go up both today and tomorrow may actually increase the incremental profits of innovation. That trade-off actually turns out that, first of all, in most standard models of demand differentiation, still results in net downwards pressure on innovation. But more importantly, both of the effects I've just mentioned, higher prices and lower innovation, are harmful to consumers. So actually the robust prediction there is that consumer welfare from both of those factors, higher prices and lower and internalization of innovation effects, will tend to be lower absent efficiencies. So ultimately the conclusion is static consumer welfare effects are likely to underestimate dynamic consumer welfare effects, because the latter is driven by future price effects and innovation effects, and needs to be some genuinely pro-competitive result of the merger, something good about the merger to turn that effect. So those are efficiencies in our general.
So if I understood correctly, your argument is that if you have a horizontal, we are of course talking about horizontal mergers now, we have one competitor less, and because you have less competition, because firms have less pressure to steal business from each other, the so-called business stealing effect, there are smaller incentives to cut prices and smaller incentives to innovate. So both things go in the same direction in terms of consumer welfare. So a merger, absent efficiencies, such as economies of scale, such as internalization of innovation spillovers, absent efficiencies, a merger reduces the incentive to decrease prices and reduces the incentives to innovate. Now, my follow-up from that is, this is all absent efficiencies, but when was the last time that the Commission considered efficiency claims by the parties?
Well, we consider them very frequently. I guess the question is, when was the last time we accepted deficiencies so as to determine the outcome of the merger? And that's a different question. I'll take the easier one first, which is the one you asked me. I think really this is about, some of the debate on innovation dynamic effects has touched upon the efficiency issues, but those actually, we haven't got to the bottom of those in the interaction with the parties, because there was been so much disagreement and dispute on the theory of harm that we never got to the actual heart of the case, which was what's good about this merger in the first place. Please tell me why this merger is actually good for consumers. So for example, sometimes R&D cuts are presented as efficiencies, where actually those cuts are simply, if anything, evidence of the theory of harm. That
of less innovation efforts.
that innovation efforts and parallel competing lines of research will be discontinued after the merger. Or market power effects from higher prices are presented as higher appropriability and hence higher innovation incentives, which may be true in isolation, but it's still, in a most direct way, a detriment to consumer welfare. And the third challenge has been merger specificity. And this goes back to the mobile telephony mergers that Jeff was mentioning. Are there alternatives, less anti-competitive alternatives, to achieve those higher investments in the network? And indeed, in some of the recent decisions that the Commission has looked at in mobile telephony, which were the ones where there was the most effort on efficiency claimed by the parties, I think the main reason for why those claims were not accepted by and large was lack of merger specificity. There was evidence on file that the parties had been talking to each other to engage in network sharing as opposed to a merger, and eventually decided to merge because it was more profitable because of the market repair effects of the merger, meaning higher prices. Now, in those circumstances, it's quite clear that the enhanced investment incentives of the merger would not be merger specific, and hence were not factored in.
Well, it was a trick and mean question. Just the mere fact that authorities clear most of the mergers means that they recognize efficiencies, otherwise they would all be blocked, of course. But I'm out of tricky questions for now, I promise. Maybe not. But for now, instead, I would like to make some general questions to all the speakers, or I'll start first with Sam, but then I want to see the reactions. And please feel free to argue argue as much as you'd like, because it's not like this conversation is being recorded. So, so you have talked a lot about innovation theories of harm so far, the fact that merger may reduce innovation incentives, but there is another theory of harm out there that many people talk about, the theory that one party may acquire the other just with the purpose of killing that innovation. The purpose is not to integrate the innovation in its own offerings, but just to destroy that innovation. So they call it killer acquisitions. I think you have some things to say about this, Jeff. So my first question is, how likely is this to happen? How likely is that a firm will acquire another just with the purpose of preventing that innovation from coming to the market?
Well, there's some evidence that it happens sometimes in the pharmaceutical industry. There is no evidence that I know of that it ever happens in the sort of big tech world that has captured so much interest today.
There is no evidence that it happens.
No evidence that I know of. Maybe I missed something, but I don't know of any. In fact, I know of one paper that suggests that the killing of the potential competitor can't explain any of the tech industry mergers except maybe one, and I would dispute the one that they mentioned. In the last, I don't remember how many years. I'll find the paper and share it with you. But in any case, the reality is that the assumption that there is a problem with killer acquisitions, other than it being theoretical curiosity, is based essentially on one paper that deals with a very stylized model of a very particular industry. So I find it, I think it's very unlikely. One of the reasons, I should just add, that I think it's very unlikely, or at least very unlikely that even if it's happening, it's being motivated by or causing anti-competitive effects, is because, and this actually goes back to even the Pacific Bio merger that you were talking about. It's very difficult, and I don't know whether enforcers ever do it, but I do know that they don't ever talk about it as being relevant to their analysis. It's very difficult to assess the extent to which incorporating non-product innovations by the purchased company, right? So these killer acquisitions are concerned with almost invariably in the pharmaceutical industry precisely with a line of research that would lead to a particular product that might compete with the incumbent product. It's never really considered the extent to which the process innovations or the managerial benefits of the better run, as the way Gail was describing Pacific Bio, perhaps an interestingly run company. What would be the benefits or what would be the effects of incorporating that company's better processes into a larger and currently more successful and more prominent company? That may not only be the motivation behind some of these mergers, but the consequence may be massively beneficial for consumers, even if the company that's purchased would have been a competitor. Because at least in the short and medium run, the one thing we know is that we're getting the benefit of their either product innovation or in this case process innovation and applying it to more products and more consumers than we were before.
So sometimes the acquirer might even have more information about
Exactly.
whether
They
that
know
innovation will be successful or not, and whether it makes sense to continue or not that innovation.
Exactly. When it comes to the killer acquisitions in the pharmaceutical industry, that's precisely what has to be happening some of the times, and it's excluded by the model in that paper as even a possibility. But sometimes it has to be sort of the opposite of what I was talking about, which is that the acquiring company kills the potential competitor, not because it was going to be a very successful potential competitor, but because it knows better than the company did that it's a dead end or it's a negative ROI proposition.
Let me ask Elder if you also share the skepticism of, about killer acquisitions, or that they tend to be harmful, and even if you'd like to discuss any particular merger where it could look as a killer acquisition but might actually not be the case.
Yeah, let me say that from the outset that I have a lot of doubts, more doubts and certainties relating this type of acquisition, so I hope I'll not be too confusing. I'm very much agree with what Geoff just said. I see the point of what is the concern, the potential concern of an antitrust authority. This you understand. You don't want a big firm to buy out a potential competitor if the objective of the transaction is simply to kill a potential competitor. That said, I have several doubts. The first one is, so people claim that usually these mergers, because of the way the thresholds have been defined so far, they pass below the threshold, okay? So what was the proposal, for instance, of the German and the Austrian antitrust authorities was to basically complement the usual thresholds with the thresholds based on the value of the transaction. Okay, this is my first concern. The first concern is that well, we are used to situations in which when you submit a merger, basically you know whether you have to notify the merger or not based on turnover, indicators, shares. So these are things that are fixed at the time in which you submit a proposal. Okay, the value is not.
But why is it a concern? I'm asking because it was not only some competition authorities. At OECD, we have repeatedly discussed the possibility of defining a merger threshold, notification threshold based on the value of transaction as a possible solution to capture mergers.
What I'm just saying is simply that I understand that the usual thresholds must be complemented in some way. I'm not sure that the proposal that was put forward is the best one, simply because I can easily imagine situations in which basically the value of the transaction, the menu of payments between the firms is designed in such a way that they can avoid. It's something that they can define at the time of the submission process.
I pay you now a certain value, and in 1 year from now, let's talk again.
Yeah, or some kind of incentive scheme behind the price of the transaction. This is the first concern. The second concern I have is that we are talking usually about mergers in industries in which the business model changes so rapidly that it's extremely difficult to anticipate what's going to be the business model in a couple of years' time sometimes, okay? It's difficult to define markets, very difficult to define markets in some of these cases. It's difficult to understand who are the effective competitors. So with all that in mind, but even assuming away all these problems, then you are faced with a transaction in which you have a counterfactual exercise, which is extremely difficult to make. Why? Because you have to disentangle between two stories. One is the bad story, the story in which, in fact, you are buying to kill, that's it. Or you have an alternative story in which you are buying because you, as Geoff was just saying, that you have some complementary assets that you would like to use in conjunction with the assets that you are acquiring to make some innovation project more successful. And it's difficult to distinguish between the two. And if the second story is true, then the merger here is basically working as a technology transfer mechanism, which is an important role for welfare. I mean, for welfare effects. So at the end of the day, what I think should be done at this point in which we are, is to rely primarily. I'm not saying that merger control is outside question. So it should be done. We should decide in which way it should be done, but it should be complemented primarily on ex post interventions like defending, protecting consumers, abuse of dominant position, and regulating dominant firms if necessary. So the right approach, a few days ago I read a note very quickly, but as far as I understood, the FTC is now doing what I think is the correct thing to do, a market study in which they selected, if I understood correctly, they selected some cases. And it's even better than what I was saying before. It's not ex post evaluation of an enforcement decision. It's an ex post evaluation about a non-enforcement decision. So they pick up some mergers that passed below the thresholds, and they are asking themselves, what would have happened if we decided to intervene? And this is the correct thing to do. And then, I mean, once you conclude, then you adjust the tools.
So
but
to
you should
gather
be
more
careful.
information before we act.
Yeah, exactly. That's my point.
Well, for a moment you got me scared
Yeah.
because I thought we'll have a second person proposing to kill merger control.
That's
but-
what I
Oh,
said.
you're the only one who proposed that.
No, it was just a question. Well,
Can I just sort of join in on
yes.
this point?
absolutely, absolutely, go ahead.
Just quickly, I think as we've been talking about, mergers that kill innovation or mergers that injure innovation are mergers that need a very close look. But to sort of go back to the question you were asking earlier about whether the agency's credit efficiencies, even in innovation cases, I mean, the answer is yes. These are fact, just as I've said before, and I'll say it again now, these are fact-based considerations. There's this famous case at the Federal Trade Commission called Genzyme Novozyme. It was the merger of two companies that were working to develop cures to an orphan drug case, an orphan disease called Pompe disease. The concern was that since the two companies were racing to create a cure, allowing them to merge would hurt the innovation and slow the cure. But in the end, the agency, the Federal Trade Commission, was persuaded that there was strong, hard evidence that actually the disease would be cured faster, that the research and development work would be sped by the two companies merging and allowing their teams to work together. So it was a consummated deal, but we chose not to challenge it.
So in that case, you actually had evidence that that measure would improve the innovation
right.
effort and
That's
result
right.
in innovation sooner. But if I understood correctly from what others said, well, you have several concerns about so-called killer acquisitions. But if I understood well, one of your concerns is that there is huge uncertainty. It's very difficult to make predictions, and at some point we might be almost speculating what's going to happen in the future when we don't have that information. Now, I'd like to do some marketing on my own of one of the reports that we prepared on merger control in dynamic markets, which was co-written with my colleague Gabriel Herday. And in this report, we try to come up with some practical solutions that would not involve speculation. We try to come with non-contentious solutions that could help assessing innovation theories of harm. And one of the possible solutions that we find is to apply tools in a similar way that we apply to traditional theories of harm. So traditionally, competition authorities look at overlapping products and geographical regions. So if we want to look in the medium term instead of the short term, we can look at pipeline products, at projects to enter new geographical regions, and if we want to assess effects over the longer term, we can look at innovation capabilities. So is a merger resulting in the concentration not of products, but of innovation capabilities? Are innovation capabilities such as technology, high-skill labor, and intellectual property rights going to be all concentrated in the hands of a few players after the merger? So this is something that you can evaluate with evidence without speculating about the future, right?
Is it a positive or a negative, though?
Sorry, come again?
Well, is it a positive or a negative?
It's a negative.
Okay, but it's not necessarily a negative, sort of just like in the example Gail just gave us, where there may be returns to scale, for example, right, where we may actually have a more efficient market if you have a concentration of those research efforts.
Well, it can...
Identifying that it exists may be important, but I'm not sure it necessarily tells you
Absolutely.
anything.
So what you're saying is that the effects can go both ways. But again, traditionally, we would look at concentration of products, and it could be good or bad, because the fact that they are more concentrated means that there is less competition, but you could have efficiencies from economies of scale. But the same reasoning applies here, the same balance. So my question is this a solution that makes sense and that, well, in this case, the European Commission and the US FTC have applied in the context of merger review?
Well, I think the approach on capabilities has been really the underlying theme in many of these recent cases. I mean, GE Alstom you mentioned, but I'm thinking also the US cases like Applied Materials to Tokyo Electron, Halliburton, Baker Hughes on both sides of the Atlantic, Bayer, Monsanto on both sides of the Atlantic, and some of the pharma cases. So as you said, you basically go upstream from the overlaps and you ask the questions, are the overlaps we observe between products or pipelines, or across products and pipelines, the result of underlying overlaps in capabilities which are highly concentrated, and hence, this is really the question for the remedy design, and hence, does the remedy need to go beyond the product and pipeline divestments to the divestment of upstream assets? Is it R&D facilities, know-how, engineers, or IP? And indeed, some of the controversy about the recent cases has been the extent of the required remedy, because the authorities felt that the concentration at the capabilities level was problematic beyond the current product and pipeline overlaps. But I think that's one approach. The second approach, obviously, to address this issue more conceptually, is to take error cost frameworks very seriously and say, what is the cost and probability of under-enforcement in this particular case? So what's the probability that these firms will bump into each other in the future? And what's the lost competition from that? For example, if the merger involves a dominant player, the lost competition from a would-be entrant may be particularly valuable. And then on the other side, on the cost of over-enforcement, what's the plausible pro-competitive mechanism that we're losing here? What's the synergy, the complementarity the merger brings about? And that framework deals with uncertainty, because I think the default position under uncertainty cannot be do not intervene, because no intervention would simply maximize the probability and cost of under-enforcement, and of course will bring down to zero the cost of probability over-enforcement. But in expected welfare terms, that's not going to be the optimal decision to take. So I think authorities will have to take error cost frameworks more seriously and enforce them in practice.
So you agree with the first approach that we discussed here, but you also say that there is a second approach which involves this error cost framework and predicting alternative scenarios, what will be the state of the world in different states of the nature, right, in different scenarios, and to assess the impact on consumer welfare on the different scenarios, maybe to do an expected value and see if that expected value is positive or negative. My question is, all this projection, won't it be very hard and result in great uncertainty in terms of enforcement decisions?
I think when I say error cost framework, I don't mean that in practice you go and measure expected welfare. In the same way as in practice we hardly do a SNP test, even though it's our framework. It's about how to frame the evidence. For example, there was a debate in pay for delay recently in Europe, and there was a judgment by the General Court a couple of weeks ago, where the UK authority asked the court, in order to have a pay for delay concern, does it have to be the case that the entrant that would be challenged or the patent has to be more likely than not to succeed in the litigation for me to have a concern? And the court, even though it didn't use error cost framework, said no, actually, that's not necessary under an effects or by object assessment. You may have a problem, a competition problem, simply because the conduct has removed the risks of competition, which is the Octavius approach in the US.
Do you take that as being a parallel approach or an identical approach to the American risk of competition language in activists?
Yes, absolutely. And I think, let's remember pay for delay as a concept where an incumbent is paying a challenger not to enter is like a merger in effect. You're buying off a competitor. There may be an efficiency or not, but the framework is very similar. So I think we've traversed this ground on conduct, and I think we can apply it, some of these concepts, to merger control without going down and measuring to the last cent the expected consumer welfare of a particular merger.
Well, Gail, let me ask if you agree with what Giulio just said, and wouldn't you be concerned about some unpredictability or subjectivity of analysis?
Well, you know, we have our statute, which is likelihood of substantial injury to competition, so that kind of answers that particular question. You know, the larger point, of course, is that we look to cases to see what can we, you know, what will the facts of an individual case show. I'll give you an example of a disruptive, we were talking a moment ago about disruptive innovators in the market. 2 years ago, the FTC brought a challenge against a merger where one of the top 2 players in a particular software market that was used by car dealerships wanted to buy the Maverick new kid on the block, the small company that was offering better terms, better service, more innovation, and really messing things up for the top 2 players. Here's my favorite quote from this case. I carry it with me always. I just happen to have it here. This was from our complaint. CDK, one of the buyer, was aware that it would face less competition after acquiring Automate, internally touting, and this was from an internal email, "We are so serious about acquiring new customers that we bought the company that has been kicking our butts." All right. That's a story about innovation, right? When you see a story like that, you appreciate the power of what innovation can do really in the marketplace. And that's why we bring cases that challenge stuff like that.
So that doesn't sound like a lot of speculation there.
It helps. An ounce of document is worth a pound of theory.
Absolutely. Mm-hmm. The other case I love, I don't bring it with me, but the case against Mallinckrodt. I don't know.
Yes,
that's an excellent case. Maybe you can give us an FTC case. I'll leave it to you. But I think, again, this is a case of a killer acquisition in a way, that you have the monopoly premium, or rather the premium that you place on acquiring a target because it protects your dominance, your market power, which is a very standard monopoly persistence result in economics. Then you had internal documents where this firm was acquiring the target and overbidding potential other acquirers precisely because of that. And I think that under Section 5, I believe, the FTC too. Okay.
Yes, Section 5 of the FTC.
Right.
Yes, we brought that case under Section 5 of the FTC Act, but on a monopolization theory.
Right.
Yes.
Well,
so exposed in this case.
Yes.
As you mentioned remedies early on, I think I will now move to one of the last questions of the day, and then I'll open to the floor. I was discussing one of the solutions that we identified, so in this report there are several others. We also talked about looking at market shares, how they evolve over time instead of taking only a static approach, how to assess barriers to entry and exit, which are crucial in these kind of markets, how to assess and consider efficiency effects. So I think we discussed a lot of non-controversial stuff in here. But having said that, there was something that I thought wouldn't be so controversial, but in the last Global Forum competition, I think it generated some disagreement both by Elder and Giulio. So now I would like to bring it back to the table, and it's precisely about remedies. So one of the possible solutions that we discussed was that given how erratic and how difficult it is to make predictions in these markets, that remedies could potentially be designed in a way that is adapted, adjusted to this dynamism. And in the case of behavioral remedies, for instance, that a potential solution would be to consider from the very beginning review clauses, so that if a behavioral remedy doesn't make sense anymore, at some point, because the market evolved, then the remedy can be eliminated. And on structural remedies, what we said was that those remedies could potentially, this again was not put forward as a definite solution, but something for consideration, and so was that these structural remedies could be in some occasions designed conditional on future market events. Let me give an example. If you don't know at the time of the merger what will happen exactly, or if there is huge unpredictability, for instance, if we don't know if a competitor will enter or not, and if that entry would be enough to address the competitive concerns, we could design something of this type. Well, in 1 year you have to divest these assets unless these guys enter within this period. Is this a crazy solution? Does it make some sense? So I think Elder and Giulio had serious concerns. So.
Yes. I kind of have an orthodox view on remedies in terms of, I think, structural remedies that replicate the competitive constraint lost from the merger, if the merger is seen as problematic, are the best solution in horizontal mergers, and even more so in mergers in dynamic markets, because you need to divest the underlying technology that allows that divested entity to remain competitive in the same way as it would have been in a counterfactual absent the merger. So automatically, if you divest the upstream assets, that's a future-proof divestment, because no matter how the market's going to evolve in the future, you created a player with this, in the same shoes of as what the target would have been absent the merger. And indeed, I think in our experience too, carve-outs or complicated mix-and-match solution or worst-of-breed solutions in some of these very complex markets tend to be very hard to design, and there's a high risk of adverse selection that you get the worst assets and don't replicate the competitive constraint that you're losing by the mergers. In that sense, clean, standalone divestments, I think, especially in terms of if you're thinking about ex-ante consumer welfare, are the best solution. Now, of course, ex-post, by definition of the uncertainty, things may turn out differently, and maybe the merger wasn't problematic. But again, we're taking an ex-ante decision based on ex-ante consumer welfare, so we need to be able and be prepared to accept the fact that ex-post perhaps intervention wasn't necessary. I don't think that that's a challenge to the decision itself.
So better to take a decision and stick with it.
Yes. Yes.
Elder?
Well, remedies is a topic that I like particularly. So let me start by saying a preliminary note is that, well, antitrust authorities in general and the Commission in particular say all the time that they prefer divestitures or structural remedies to behavioral remedies, which for instance, if you look at the EC notice on remedies, which is more than 10 years old now, then it's clearly said that structural remedies, they do not require monitoring, so this is the way to go, this is the way we prefer. But then you look at the data, and you see that, structural remedies are a minority of the cases. And actually the Commission in particular has been following much more complicated solutions, like access remedies, IP divestitures, carve-outs, and so on, which clearly involve some uncertainty. So the likelihood that they do not resolve or they do not solve the anti-competitive concern, or they only partially do so, in my view, is high. Okay? This is just a preliminary note. Then, as far as the proposal is concerned, I understand the logic, which is, well, since these markets are dynamic, so let's not try to commit for good to a given solution, and both in the case of structural remedies and in the case of behavioral remedies, let's try to adjust them on the way, if necessary. That's more or less the idea, if I got it right. I understand the idea, okay, but again, what I think this solution is leading us to is basically to put competition authorities closer to the position of sectoral regulator. Okay, so you have to monitor then the evolution of the industry structure and the solution that you propose along the way. Okay, and you have to adjust it. Well, if that's the case, then my question is, why don't you simply involve sectoral regulators? I mean, they are the relevant ones for each case. So they are usually the ones that have deep knowledge of the industry. So at least we should work closely with them. Point number one. The second thing, the second note I would like to make at this point is, again, a point that I made before, which is the importance for me of ex post evaluation. In Remedies, it's again very relevant to try and understand whether our proposed solution is doing its job correctly or not. And if not, then at least in future decisions, we adjust. And I think that's the correct way to adjust the toolbox which is available for merger control.
So if I understood correctly, you have an open mind to this solution, but you are not on, but you are not 100% convinced.
Yeah, you can say so.
Well, but you also suggested ex post evaluations, which I think no one in this panel would disagree with.
No, but I think you're too quick to suggest that the only way to mitigate the uncertainty problems is through a sectoral regulator, for example. I think the idea of acknowledging, especially if you acknowledge that sometimes dynamic consequences may be absolutely the most important and or long-term consequences, and that also by definition we know the least about them, considering how to structure remedies to mitigate the consequence of that uncertainty seems sort of like a no-brainer, even purely within the antitrust context. You know, again, if you think that antitrust should be done and that antitrust regulators know enough to make antitrust interventions, then you must also think that they know enough to design remedies that might mitigate it when they're wrong, and increase the likelihood that we can make corrections subsequently. Now, I think there's a lot of possibility of abuse. I think you know the arguments against behavioral remedies tend to be ones about when the regulators sort of do badly. You know, almost it's like a rent-seeking sort of argument. But if you do behavioral remedies right,
They could work.
I don't think they're inherently problematic. In fact, this is especially true, I think, in vertical contexts where the argument is it costs a lot to monitor. Well, the agencies are supposed to be monitoring anyway. The idea is that the harm that might come from a vertical merger is essentially in the U.S., a Section 1 effect, a foreclosure effect. It's what they're supposed to be monitoring for and protecting against anyway, except in this case, they've been alerted ahead of time as to exactly where it might occur and how it might occur. I mean, the monitoring costs are way lower than they would be sort of in the abstract relative to what the agency is supposed to be doing. So I don't really see that as a very good argument, at the very least in vertical context.
So the concern is an anti-competitive strategy after the merger, and that's why the behavior remedies are often accepted in this context. Right. Anyway, probably not to get inside vertical mergers, because that could give a whole other session, which would actually be great. But I would still like to give some space for Q&A from the floor. So if anyone has any question you would like to receive. I'll just alert that we, for this particular session, we set a 30 seconds limit, so the mic will stop working after the 30 seconds, just to consider that. Anyway, anyone? Well, you still have 30 seconds, so. Okay, I don't think there are questions from the floor, so I can say I was lying. There was no limit. Of course, we did not program that, but it was worth the try. Well, in that case, maybe I would like to give 1 minute to each of the speakers to do some concluding remarks. Maybe you can start, Giulio.
Well, I think the topic today is merger control in dynamic markets. I mean, I think most markets are dynamic to some degree. So this is really a panel about merger control. So some of the issues we've discussed are the fundamentals of merger control. So I think let's remember, especially authorities, business ceiling effects are important. So closeness of competition is an important determinant. Barriers to entry are important. The fact that we're thinking about dynamic markets doesn't make them less important, actually makes them more important. So be confident in applying the toolbox for unilateral effects, also when it comes to dynamic markets. And when it comes to countervailing effects, efficiencies, be consistent. So if the time frame for the competitive assessment of harm is medium term, the time frame for efficiency should be medium term. If the standard of assessment for harm is qualitative, then the standard of assessment for efficiencies may have to be qualitative too. So a consistent approach here will lead to optimal enforcement decision, again, in the context of an error cost framework.
Let me just react. I was hoping that no one would point that out, because now from what you say, it seems like we have to change the title of this paper to Fundamentals in Merger Control. I was hoping no one would notice that. Gail?
Okay. So I guess I'll make one old point and one somewhat new point. In closing, the old point is that the emergence of dynamic, unpredictable, disruptive business models and antitrust is nothing new, and we use the tools we have to challenge them where appropriate to promote consumer welfare. I guess if I were going to make one new point, though, don't forget, when we think about mergers, at least in the United States, we always think about Section 7. Don't forget about Section 2. It doesn't apply everywhere, but in some markets, and they might be relevant to the ones we've been talking about today, where a large incumbent is buying a small competitor. You might also have a Section 2 monopolization claim on your hand. One of the companies has to have monopoly power. That's not routine in merger cases. But the monopolist has to be acquiring a firm that it has identified as a competitive threat. And of course, we need to evaluate the pro-competitive story of efficiencies and pro-competitive justifications. But in the right circumstances, Section 2 can also be relevant. For example, Illumina PacBio. We brought that case under Section 7 and Section 2.
Geoffrey?
I'll just pick one thing. I think remembering the extent of uncertainty around enforcement generally, as Giulio points out, this is true of all mergers, all merger enforcement, but especially true in what we think of when we think of dynamic markets. I think bearing that uncertainty in mind, in particular, goes to something that Gail just said, and that is a great topic for conversation generally, which is, in fact, the role of hot docs and that kind of evidence and its appropriate interpretation. And you were talking about papers I've written. I think the first paper I wrote was about the sort of over-reliance on, this was many years ago, I was very young, I had more hair, no, less hair, sorry, less hair then. One of the real problems is, and Giulio mentioned this before, that often the merging parties don't even know exactly what the efficiency gains may be, or sort of why they're merging. Even if they have an anti-competitive intent, of course, that doesn't mean the effect would be anti-competitive. And in particular, when we're in a climate in which people are talking about shifting burdens and presumptions, I think we need to be really careful about that, because as hard as it may be for the agencies to make decisions under this degree of uncertainty, I think imposing that obligation on businesses will have all kinds of negative effects, and often will mean, perhaps more often, mean that, we'll have a lot of type 2 errors, because they can't necessarily elucidate the efficiency reasons for their merger, but that doesn't mean that they don't exist.
Oh, that's a very good point. Elder?
Yeah, well, I fully agree with Giulio when he says that most markets are dynamic. That means that most markets are uncertain, as uncertainty is very high. I should say that I think that competition policy rules are quite robust. The toolbox which is available for competition enforcement is quite good. So I would propose to be very careful in adjusting the toolbox. And I would propose some kind of approach, like instead of changing the toolbox and then let's see what happens, let's do what the game theorists usually call backward induction. Okay, let's rely on, this can be done in two ways, which the one way is to complement ex-ante intervention with ex-post remedies. Okay, and the second thing, which I think is highly useful, is to perform as much as possible ex-post evaluation of enforcement decisions. I know that this is the third time I'm mentioning this, but for me this is the way. Let's identify type 1 and type 2 errors. Let's see where the things didn't go well, and then we correct the tools. I think that's the recommendation I would leave here. Thank you.
If you allow me also to say a few words, I feel from this discussion that we end in a very positive note, because I noticed that in previous discussions about these topics, we usually conclude we are doomed, it's very difficult to make predictions, we have no solutions, there is no way that we can address challenge in these markets. And I think the conclusions in this panel were very different. We have tools, we can work with those tools, and there are several things that can be done to do the job right and to assess the effects of mergers in dynamic markets, or in all markets apparently, and to make the right decisions. So I think that was a very positive note. I would like to thank you all for several reasons. First, for coming here, of course. Some of you interrupted your vacations to come here. Others came from very far. But I think we have also to thank you for an additional reason for agreeing to engage in a discussion with this specific format. Because for disclosure, I did not share in advance any questions with the speakers. I told them very briefly the topic, and they had no idea what we'll be talking about. In some cases, I gave them a hint. I might be asking about this or that sensitive topic, so that's why they have some notes, but this was not staged in any way. So in the name of the competition division, we really, really thank you for accepting to engage in this kind of discussion. So thank you so much, and huge applause.